In this video, I want to talk about the remedies that are available for copyright infringement. You'll find this predominantly in section 115 of the Copyright Act. The primary remedy that we see in copyright actions most often is the injunction. Plaintiffs often want the ability to prevent people from making further reproductions, from further publishing or communicating copyright material. So the courts have power given in 115 subsection 2 to grant injunctions subject to any terms as the court sees fit. It's quite a broad-ranging power, and it's available usually as of right to the plaintiff. Plaintiffs are also entitled to elect either between receiving damages for copyright infringement or an account of profits. So the difference is that if there has been significant harm to the copyright owner, then they might elect to pursue damages. If, on the other hand, the copyright infringement hasn't necessarily harmed the market of the copyright owner, hasn't harmed the copyright owner's revenues, but the infringing party has made a lot of money from that use, then in that case, the court might order, and the plaintiff might elect to pursue an account of profits, to requiring the defendant to pay a sum determined by the court in proportion to the value that they accrued from the infringing uses. There is, importantly, a defense in 115 subsection 3 of innocent dissemination. This means that because copyright is a tort of strict liability, people can be liable even if they didn't know that the materials that they were selling or communicating infringed copyright, someone else's copyright interests. The important limitation is that damages and account of profits are not available to plaintiffs where the defendant did not know of the infringement. This is called the innocent infringer defense, and you'll see it, for example, in people who sell goods that they don't realize are counterfeit or infringing copyright goods. It only applies up until the point at which they're put on notice. So the common strategy, of course, is for plaintiffs to put defendants on notice that the material that they are selling, communicating, distributing is covered by copyright and that they're doing it in an infringing way in order to then be able to claim future damages or account of profits. There are also provisions in section 115 for the court to award additional damages as it sees fit. And you'll see that the courts are willing to award additional damages based on the flagrancy of infringing conduct. This is designed both as a punitive component to damage awards and as a disincentive to engage in flagrant infringing behaviour. Importantly, courts determining intellectual property matters also have the power to grant other remedies that are not specifically set out in the Act, but are within the jurisdiction, the inherent jurisdiction of the court, or within the jurisdiction conferred by statute on, for example, the Federal Court of Australia. Importantly, plaintiffs also have certain rights in respect of infringing copies of goods. So, particularly section 116 provides for conversion damages, where the owner of copyright in a work or other subject matter may bring an action for conversion in relation to either infringing copies or devices that are used or intended to be used to make infringing copies. And this is quite important for people dealing with imported copies of infringing material or dealing with counterfeit operations to create large-scale infringing materials for market. This provision deems a copyright owner to be the owner of any of the infringing copies and any devices. So the copyright owner is entitled to seize the property of the defendant in a successful action, not only the infringing copies themselves, but the machines that are used to make those infringing copies. Quite a powerful situation, and you see a lot of plaintiffs in physical actions, you see a lot of plaintiffs in actions involving physical goods to seek the delivery up of infringing materials and then to have a big burning or a trashing of the existing infringing counterfeit copies. Another remedy that we see used quite importantly in the digital environment is the Anton Pillar order. This is a search and seizure order, usually an ex parte interlocutory injunction granted to plaintiffs to require defendants to permit the plaintiff's solicitors to enter premises and inspect and remove defined articles and documents. So it's particularly used where there is a significant risk that the plaintiff will destroy the evidence of infringing copies. And we've seen it used, for example, in the Kazaa file sharing litigation, where the federal courts enabled the plaintiffs to turn up to Kazaa's offices and take away the servers for the purposes of preserving evidentiary documentation before the operators of that file sharing network had an opportunity to learn of the action and remove the evidence stored on those hard drives. This is quite an important exercise of power in the digital age, particularly when records are so easily destroyed. There are also concerns about privacy implications because it's an ex parte order. There are concerns that that the material that is taken up might infringe the rights of third parties.